So here we've got a form, right? I think that this form's most likely been updated, but this is one of the government forms for appeal. Now, the thing is, right, with the Crown Prosecution Service, I'm quite certain that Angela Ditchfield's case was in the Magistrates' Court, not in the Crown Court, when she got acquitted. I'm quite certain, we can check up on it. But after she was acquitted, the Crown Prosecution Service went to get her convicted. They went after her to get her convicted because they weren't happy with it. But they went to the High Court. So there you've got a move from Magistrates' Court to High Court without the Crown Court. You can go check up on that to make sure I'm right, but I'm quite certain that's what's happened. So I don't know why the Crown Prosecutor did that, and why they don't go to the Crown Court. You know, if they're appealing the acquittal, why do they go to the High Court? Now, I've just done a video talking about, you know, this jurisdiction's going up and up and up and up, but, you know, the Ecclesiastical Court, the Court of High Commission was a very, very high court. And there's always been this right to appeal, petition the king, which people were doing this without even getting a conviction. They were just, you know, asking for it to be raised up, not like in some sort of sequential order. The thing is, right, I'm bringing a case myself, a complaint myself against a judge, right? I've got a case against a judge in relation to, though, a case that was in the Magistrates' Court. But we don't go to the Crown Court. The Investigations Office and the Judicial Authority, which deals with it, is within the High Court. It's a branch of the High Court, right? Now, we see that movement with the CPS. With Angela Ditchfield, they go from Magistrates' Court to High Court without touching the Crown Court, right? And obviously, they're the one bringing the charge. Now, the thing is, with my case with Judicial Conduct Office, which is within the High Court, it's a section of the High Court, over a matter concerning the Magistrates' Court case and the judge against me in the Magistrates' Court, we see this similar movement, right? But instead of the Crown Prosecution Service against Angela Ditchfield, we've got me versus the district judge, right? But both those cases originated in Magistrates' Court, right? Now, I've got to the stage where it's my case, I'm submitting the case, and I've got my own, the High Court, basically, the Royal Courts of Justice is a High Court. I've got a case, and I can submit evidence. I have the ability to submit evidence in that case. I can submit statements, I can submit videos, images, material, right? Now, if I have got the facilitation, the button, the casework access to submit, right, lay evidence, then surely it's through the Judicial Conduct Office, jurisdiction and authority within the High Court. So I filled in Sabina forms, right? Because I'm like, well, I want to submit this evidence and I want to submit that evidence, but the people aren't giving it over. So, you know, like any prosecutor or any, you know, police bringing a case, like the CPS had against Angela Ditchfield, they go from Magistrates' Court to High Court. In a way, it's similar, right? Now, I should be able to get hold of and compel evidence. Ask the court, ask the Judicial Conduct of Investigation Office to get things signed for evidence I want to submit and upload, because I've got the option to do that, right? Under that jurisdictive office. Now, but the thing is, with my conviction in the magistrates' court, it's been discharged, right? Because I was ill for a long time. So, like with Angela Ditchfield, the Crown Prosecution Service weren't happy with Angela Ditchfield being acquitted, so they went to the High Court to get her convicted, right? Now, the thing is, with my order in the Magistrates' Court, I was ill for a long time, so my probation officer, under, overriding objectives and rights, went to apply to get my order discharged. The sentence discharged, not the conviction. I don't think it's not the conviction being discharged, but the sentence, right? It's not an appeal. It's just a discharge of the sentence, right? But so the thing is, if I had have appealed either my conviction or appealed the sentence, there's a form here, right? This is the form that they had around the time. Now, on this form, right, the thing is, on the form, right, it says here, I want my application to be considered by, please tick, the Magistrates' Court or the Crown Court. You can apply to both. So, now most of the time, when you appeal a conviction, right, you usually apply to the Crown Court, right? Now, you can, by this form, this is a government form, apply to the same court, the Magistrates' Court, to get either your sentence changed or even your conviction overturned. Now, what they're trying to tell you and what they're trying to make out is that you can only appeal an order or conviction to a higher court, right? Not the same court. But that's not the truth. That's not the case, because, for example, with my sentence and my conviction, when I'm ill for a long time, the probation service go to the courts and they get the order changed, the sentence changed, discharged, not by the Crown Court, by the same court, right? Now, it's very, 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 very rare that a magistrate's court, after making an order, will hear the case again, right, or overturn your conviction. But it's not impossible. So I don't know why they insist on this hierarchical system when you've got to go to the higher court, right? Now, what's happening? This is a question now. When Angela Ditchfield receives a conviction from an acquittal, when Angela Ditchfield receives an acquittal from a magistrate's court, right, and the prosecutor is not happy with it and it wants to get, the acquittal overturned and get a conviction, why isn't the Crown prosecutor either applying back to the same court, magistrate's court, or ticking this box to go to the Crown Court? They go to the High Court of Appeal, right? The High Court. Now, do you see a box on here for the High Court? No. You don't see a box on here for the High Court. Do you see a box on here for the Privy Council? For the Supreme Court? They say we've got to do it in a certain order, right? But that isn't the case. The magistrates court, almost 99.9% of the time, due to stubbornness, always refuse to change an order or conviction or overturn it. And they keep saying that they can, but why is it on the form here? Why is it even on the form? I want my application to be considered by the magistrates court, the Crown Court. Well, if you start in the magistrates court, or if you can't go down to a magistrates court from a higher court, then why would it be on there? Now, we know the magistrates court can make changes to convictions or sentences because the probation service get them changed there. So again, we've got this stubbornness, this lies, this denial that, we can't do anything, you can't do that, you can't do that, you can't do that, you can't do that all the time. They're saying, but it's lies. It's wrong. It's lies. Now, I believe that really, if this Crown prosecutor can apply to the High Court a case that was heard in a magistrate's court, then why can't anyone else, right? Now, the thing with my case against DJ Watson is that they've got these advisory committees that you can write to complain about magistrates, but when you go to the official online procedure against a judge is at the High Court. And this is an official case. This is an official... You are actually bringing the equivalent of bringing a prosecution yourself against a judge, but concerning an existing case that existed. Although it's not about you. It's not about you and your case, but obviously the reference to the matter will be the same case because that is the case which, how do you cite it? How do you name it? How do you label which matter it concerns? Well, it concerns, the judge in the hearing for that case number, right? So, I can submit files, I can submit evidence, and if I can't get hold of that evidence, if I can't get hold of the files, then I have to make a request to the Judicial Conduct Office, which is within the High Court, to compel that evidence or to compel those files or to compel that material because I want to submit it. Why not? I can submit what I want, so I can ask them. Now, I filled some forms in to do that. Now, this is where I'm now starting to kind of think of what's possible in law and what's possible to ask of a court. Given that, here, you can ask for a magistrate's court, you can apply to it to be reconsidered by a magistrate's court or the Crown Court, but also you could even there's nothing stopping you putting the King or the Privy Council in there, really. It's an authority jurisdiction. How can the Crown Prosecution Service go from a magistrate's court to a High Court, right? If there's a certain order and procedure to follow. Why can't you tick Supreme Court? And then why can't you tick, you want it investigated by the inquiry? Now, the thing with the Inquiries Act, it says the inquiries can go on alongside existing cases and investigations. Inquiries are allowed to go on alongside existing cases and investigations, right? But what happens if your investigation is to get an public inquiry? What happens if your investigation is to obtain the inquiry? And the inquiry refers criminal and civil matters to the High Court. Now, the thing is that my complaint and my case against Nicholas Watson, DJ Watson, is that he broke the law of the criminal Law Act 1967 by obstructing my investigation. His actions, his conviction against me basically intervened in my investigation, obstructed it, and he removed my ability to pursue that investigation, to even conduct the investigation by taking my driving license off me. And the thing is, I need the driving license for that investigation, really. And the thing is, right, that I'm bringing a case to the High Court now, but it's not like in the main court. It's through a special department of the court that still uses the courts. And I'm allowed to submit information and data in my investigation against Watson, and I can compel, I'm applying to compel evidence, subpoena evidence, right? Which I can do. I've got a form to upload evidence, so if I can't get hold of the evidence, then I can ask them to use court powers to get it for me. Now, the thing is, right, what happens if the High Court that's dealing with this matter is a higher jurisdiction and judges can make orders in relation to my case as plaintiff, not the case against me by Watson, but the case against Watson that I'm bringing to the High Court. If I can compel evidence and information, right, and if I can ask judges for powers, I have a case filed in the High Court with a special branch of the High Court, right? And also, let's note that I've already supposedly had my sentence discharged due to being ill, right, for a long time. But it was the probation service that applied to the magistrates' courts for the discharge. Like, here, look, this is this. I want my applications to be considered by the magistrates' court or the Crown Court. Will the probation service get the issues to do with your overriding objectives of medical status? They get it considered by the magistrates' court, right? Here is a Crown Court. Now, I've got a case against Watson in the High Court, in the special branch of the High Court, in the Judicial Investigations branch, right? Which is, it's above Magistrates Court and High Court, right? And it's my own case, right? But, look here, right? So look at this. Are you asking the court to release you on bail before your appeal? Well, I haven't actually got an appeal. I've actually got I am bringing a grievance, a complaint to a higher court about a individual concerning the lower court, right? But I don't need to apply for release or bail. I've actually had my sentence discharged. But that was for the community service, right? But what about my driving license? Well, here, Section 5, right? This is like a standard appeal form. Other applications. So this is other types of application you can make to courts, right? Are you asking the court to suspend your disqualification? For example, your disqualification from driving. Please tick yes or no. If you have ticked yes, explain your reasons here, right? Well, you can get you can get a court to suspend something, right? You can get a court to suspend something You can ask them to suspend something. They can do that, right? Like the Crown Court or the Magistrates Court or any other a higher court. Now, the thing is, if we look at that Bastwick and the Burton case to do with the in the 1641, the petitions, and when they got convicted by the High Court of Commission, and then they immediately appealed Star Chamber, right, petitioning the King, but then they got convicted, and then they actually, those men, they actually got their ears cut off as part of the sentence, but they also had to pay fines. But also they had their their license to practice removed. Like their clergy. They had their when they're on, if you're an ordained priest and you've got, or if you've got a degree, they had their degrees taken away. They had their academic qualifications stripped. And later on, when their wives petitioned the House of Commons for their release, the House of Commons ordered that they had the money, the fines refunded, and their academic qualifications restored, and their license to practice and so forth. You get this like with doctors license to practice and so forth. Nowadays, doctors can lose their license to practice and so forth, right? Things like that. Now, the thing is, all you do when you're making an appeal to a higher court or a higher jurisdiction, if you want your license disqualification suspended, all you're doing on this form is ticking a box and filling out some reasons. I've actually done this myself. I actually appealed to the Crown Court on one conviction, and I applied for my driving license being disqualification being suspended, and I got my license back. I've done this, but I kind of bottled it, and I got scared of going to Crown Court, and I withdrew my appeal. So obviously the suspension was restored. They took my driving license back off me again. But what I'm meaning to say is, you haven't even had the appeal or gone on trial pending the appeal. Merely because you've applied, they give you your driving license back. They suspend an order, right? This is court powers. This is asking courts to exercise powers. This is applications and directions, right? Now, when you are bringing a civil case to any jurisdiction, or when you are prosecuting a criminal case or whatever, you can give directions. Now, this is what I'm doing with the High Court now, with my case against Watson. I've with this case, I can upload evidence. I can upload video. I can upload photos and statements, and I can choose to submit things, whether they disregard it or whether they use it or not. So when I want to submit something that I don't have access to, or I'm being withheld access to, like from YouTube, data, videos, my channel, or the BBC files, records on Nick Freeman broadcasts, if they won't give me the information, and I can't upload it to the case, so I need to compel it. I need to get the court to, I have to subpoena it. I've got the right to do that. I'm the claimant. I'm the plaintiff. So the thing is, now this is a question based on this form. This form is just tick a box and write some words, but it encompasses all the available things that you can request. But there are some things that you can request and do which aren't in the form. But to know that, you would have to be a qualified lawyer or educated in law or a barrister and know the full extent and criteria of what can be done. This is when you get into the area of undertakings. I've actually submitted undertakings before to courts. I filled in undertaking forms, which is basically like a request for the prosecution to do something. You want the prosecution to do something or give something or make an agreement. It's called an undertaking, and you fill the request form in and you send a copy to the court and you send a copy to the prosecution. But on those occasions, the prosecution were bigoted and aloof and just ignored it and blanked it. Even though I filled it in properly. But I've had forms for an adjournment before. I've successfully completed adjournment forms and other forms and basic things like that. But, when you aren't fully clear on, when you know what you're doing, what you end up doing is incurring more cost. If you can't fully see it through, then you're stuck, because if you end up having more and more hearings, then you're incurring more and more court costs on yourself. And if you're quite not sure of the direction you're going in, then you end up ending up with a lot of court costs to pay. And the thing is that, but it's usually because the Crown Prosecution Service will not comply, will not respond, will not agree. This is usually a breach of procedure rules, right? You see, there are lots of things you can do, like assisting offenders. You can ask for immunity. You can apply for immunity for the Attorney General. Why not? If you had a very, very, very strong solicitor and barrister, you can do all kinds of things. You can get the CPS to agree with an undertaking for it to take you on as a witness for the police. If you wanted to try, there's nothing to prevent you doing that. It's a legitimate avenue of direction. They might not agree to it, but you could try and get the judge to agree to it, even if the CPS don't agree to it. What else could you do? You can subpoena things, get warrants, all kinds of things. You can get some people, when they're in a court, they have these meeting rooms within the court building when the CPS make offers and deals with them, really. They say, you want you to agree to, if you change your plea and so far and so forth. But you're getting into the area of favour then. You got to be careful, because you're getting into the area of favour, and this is why I think that the conditional offers might be illegal, because the judges have got an oath that they can't do favours. Like, if you give evidence or make pleas in exchange for lenient sentences and so forth, you're meant to choose yourself whether you're guilty or not guilty. And if you do plead guilty, right, then you can give mitigating circumstances and you can, beg for a lower sentence. You've already admitted guilt, but they're not meant to offer you a lower sentence to get a confession out of you or to give more evidence and so forth, because then that's getting favour. You might as well, it's like, people putting a wanted poster out and offering a reward. It's more like saying, if you admit you're guilty, we'll pay a fine, which you can't do that on other people. You can ask people to come forward, as witnesses against someone, but the actual defendant can't be given, they can't be given you can't give the defendant £100 for confessing or whatever, because then you're doing them a favour. This is why I think the conditional offers are unlawful, but we're getting into that later. So I'm starting to think now, you can get any court, particularly a court with higher jurisdiction, you can apply, you can make a request for. So I'm thinking now that I can ask the Judicial Conduct Office that is within the Royal Courts of Justice. I could ask them if they could get a suspension from one of the judges to authorise it, or my driving licence disqualification. There's no reason why I couldn't apply for that if I can apply for subpoenas and things like that. But I'd have to put a reason in. If you have to, yes, explain your reasons here. Well, I could make an application. So there's nothing stopping me from making an application, or it's a legitimate thing, a request to enter. I could ask for a suspension on my disqualification, at least pending this investigation, or I could even ask for a permanent suspension of it. I could ask for a stay. Well, there's something called staying. You can stay something, and there are various other things you can ask for, but it can only be actioned by a higher court. I'm quite sure that if you've got an investigation going into the conduct of a judge that is under question, that you can ask for the higher court who is investigating it to get a suspension of any of the sentences, particularly going on the basis that I've already had a sentence. I've already had part of the sentence discharged. Although I suppose there's always a risk of them, I suppose there's always a risk of, you ending up getting more severe punishment. But the case isn't against me. This case is against Watson, and I am the claimant and I am the plaintiff. So on the basis that I am the claimant and I'm the plaintiff against Watson, I'm meant to have witness immunity. Because I am the person bringing the charge against Watson. It's not an appeal of my case, but if I can subpoena material and documents for this investigation, I'm starting to think that if I need the vehicle for investigative purposes, or Watson's actions have intervened in my investigation into illegal road signage, which is House of Commons investigation, then there are grounds for me asking for a suspension of the driving disqualification from the High Court through the Judicial Conduct Investigations Office. They can get a judge. They could get a High Court judge to do that. And also, the thing is, through the Constitutional Reform Act 2005, the Lord Chief Justice, who is in charge of the Judicial Conduct Investigations Office, can lay any documents and requests or representations to the House of Commons, right? So, they can request that there be an inquiry, that my petition number gets an inquiry, that it gets a public inquiry, all my evidence and, legal road signage investigation, petition number for my case, they actually can lay to the House of Commons Petitions Committee that, I've got a case against Watson regarding my petition number, and I want to raise the issue that there's a lot of illegal road signage, and there should be a public inquiry which can be initiated by a minister, and the Judicial Conduct Investigations Office head can do that, and they can also get my driving licence disqualification suspended and lifted. And there doesn't necessarily need to be any specific duration of time for that. It could be indefinitely. Could be an indefinite suspension. And I don't think that I don't think that they could. I don't think that I could. I don't think that they can make a. I don't think that I can. I don't think I can be punished for asking either or for bringing this, because I'm the plaintiff and I'm the claimant, and my claim is that I can't continue with the investigation because I've had my driving license taken off me. So you can apply to the court for it being suspended, the disqualification. And regarding my petition case and evidence, the Judicial Conduct Investigation Office can make representations to the House of Commons Petitions Committee about it, according to the Constitution Act. So there is a line, there is a representation and inquiry line from the Judicial Investigations Office to the House of Commons Petitions Committee through that Constitutional Reform Act 2005, and even to the Privy Council, because actually you got the right to petition the King. It's the right to petition the King, and the King has still got a judicial authority in the Privy Council anyway, and that is still in place with the Constitutional Reform Act 2005. And there are more boxes that these two boxes here, Magistrates Court, Crown Court, or even Supreme Court, they're being savvy about what actual jurisdictions there are, because the House of Commons Petitions Committee or Inquiry Tribunal, it is a jurisdiction, even though it can only do certain things. The Privy Council still exists with a judicial authority separate from the Supreme Court. So even though the House of Lords appeal that jurisdiction act to the House of Lords, but when you have petitions to either of the Houses of Parliament or the King, that's an additional authority. It's an additional authority to the one in the Appeal Act Jurisdiction Act when you do by petition and a prayer. So there's still the Privy Council jurisdiction authority that exists to petition the King for appeal, but I petitioned the Queen in the first place over my investigation. So, and she referred it to ministers, which is House of Commons, which is under the Petitions Committee jurisdiction anyway. So they're meant to be dealing with it anyway, which is rightly filed with the House of Commons Petitions Committee. I think I might fill this in and send it to... I think I'm going to submit this to Royal Courts of Justice. Why? Because of the reason that the Crown Prosecution Service filed a case from a magistrates court with Angela Ditchfield versus Crown straight to the Royal Courts of to the High Court, and they didn't touch the Crown Court. So I've got a case. I've got a case against Watson, and it's on a matter from the magistrates court straight to the High Court. It doesn't touch the Crown Court. And why can't I petition the Privy Council? I can do. The box isn't on here for that, because really they don't want you to know that you can do it, but you can. You can also, I can ask for my driving disqualification to be suspended as well, either for a certain period of time or permanently, a permanent suspension. There's nothing. It's almost like you can get proceedings stayed, but I don't want to stay proceedings because I'm not appealing. I'm not appealing the conviction at Loughborough, because I've already had the sentence discharged. I'm not appealing the conviction, but I can ask for the disqualification to be suspended permanently by the High Court. I can ask the Judicial Conduct Office investigation to get one of the justices to suspend it. Why? Because it's obstructing my investigation. And really, right, I'm bringing a case against DJ Watson. So, I'm being hindered for pursuing that properly. I'm incapacitated for that. Although they'll, they only want, to know things in concerning that. But, it does concern that because, what concerns that is my Parliament petition. What concerns that is the fact that I got an investigation to Parliament and it's under House of Commons jurisdiction and all those matters are meant to be dealt with the High Court. Anyway, that's the point. That's the point. The point is that DJ Watson never had the jurisdiction to convict me in the Magistrates Court for matters that I was under House of Commons investigation. It had to be dealt with by the High Court. Now, that is, look at Angela Ditchfield. Why did the Crown Prosecution Service go to the High Court? Because why didn't they go to the Crown Court? Clearly, obviously, they don't. They go to the High Court. So, why didn't the Crown Prosecution Service take me to the High Court? Like Angela Ditchfield, why didn't they take me to the High Court in the first place? Because DJ Watson, he's not within his jurisdiction. Anyway, that's the point. So maybe I can fill this in and complete it.